Welcome to another episode of Image Rights by N. Mashinini, the only podcast dedicated to image rights in Africa and around the globe. Today, I am excited to have Kenneth Muhangi from Uganda. Kenneth Muhangi specializes in intellectual property and technology law. Kenneth also holds a master's degree in international commercial law from the University of South Wales, a bachelor's degree in law, LLB honors, and a diploma in legal practice from the Law Development Center. Kenneth is a lecturer and a head of subject intellectual property and cyber law at the Uganda Christian University. He also holds and has conducted lectures in cyber law at Makerere University Law School. Kenneth is a member of the Africa List, an exclusive community of next generation CEOs building Africa's top 100 companies supported by the CDC Group. He is the chair of the East Africa Law Society Technology, Media and Telecommunications Committee. He also sits on the Committee of Management of Intellectual Property Assets under the Presidential Initiative on Banana Industrial Development. Kenneth also represents Uganda at the Fourth Industrial Revolution Portfolio Communities of the Center for Fourth Industrial Revolution of the World Economic Forum. This 4IR portfolio communities include AI, blockchain, Internet of Things, digital trade, data policy, and drones. Kenneth has also been engaged by the World Bank to support the preparation of the African Drone Forum's regulatory track under the World Economic Forum guidance. Kenneth has been recognized as a leading intellectual property lawyer by the World Trademark Review Guide. And in 2020, Kenneth was also recognized as Africa's Male Partner of the Year at the 2020 Africa Legal Awards and among the top 50 leading in legal innovations in Africa at the Africa Legal Innovations Awards. What a mouthful, Kenneth. Welcome to the show.
Thank you very much, Dr. Nomalanga. Thank you. Very happy to be here.
Look, so I have a keen interest on image rights, and I've been looking at this topic for a couple of years now. It's something that I took interest in when I was still doing my LLB studies, and I took it up further when I started the doctorate, which I completed at the end of last year. And so this podcast is very dear to me in the sense that it is an extension of my research as I try to educate people around the globe about the protection of image rights and how they intersect with social media, memes, drones, deep fakes, and so forth. And so I thought for this season, I want to do an African perspective. I've looked at, or had interviews rather with people from Nigeria, Ethiopia, as well as Kenya. And I thought, let's have a look at Ugandan law on the protection of image rights. And I thought you'd be the best person to come and answer a couple of questions for our audience. So I want to just pick your brain today, firstly, about the Ugandan law protection for image rights. What does it look like, the landscape of image rights protection in Ugandan law?
Okay, well, I hope you can all hear me. First of all, really, it's an honor to be heard or to appear on your podcast, Dr. Nomalanga. I have watched a few episodes, and I'm really, really interested in having discussions around intellectual property, and in particular around emerging areas like image rights. Well, depending on the jurisdiction that you're actually speaking from, because I think South Africa is a more developed jurisdiction when it comes to intellectual property, especially around image rights and the like. And so the question you asked me was whether Ugandan law recognizes image rights. The answer is yes and no. No, in the sense that, so for all the listeners, you will appreciate that for most of our countries, we get our law mostly from colonialists, or we are signatories to international conventions. So one of those conventions that we'll be looking at is the Berne Convention, and also perhaps the Paris Agreement. Those are all agreements that really talk about intellectual property, and in particular, copyright. And so from those particular laws, we find that as a result of our reception clauses, the time that we received these laws in our jurisdictions, in particular Uganda, the law only envisaged copyright protection being the protection of of course, literary and artistic works. You can look at the different extensions, maps, etc. And image rights in particular, image rights are tied to the right to publicity. And so image rights relate to an individual. If I, Kenneth, want my likeness to advertise a product, or for me to be to feature somewhere where my likeness, either my facial features or even my hands or any part of my body really, and if I have unique identifying features that set me apart perhaps from other people, and so if my likeness would then be used in a manner that would benefit me, not only financially, but also in terms of me getting that publicity as a result of my likeness used in a manner that I have mentioned, then our law does not specifically address or mention image rights. And so the law that I'm looking at in Uganda is the Copyright and Neighboring Rights Act, which, as I mentioned, provides for copyright in general. But the copyright, if you look at the law, it breaks down what items or what things can be able to get or subject to copyright protection. So as I mentioned to you, things like literary and artistic works, things like maps and other works of applied art. You're looking at music. You're looking at all these aspects that are generally tied to the mind, where you have creations of the mind. So these are more esoteric rather than exoteric in the sense that you have, if you're looking at likeness, then the law does not look at that. But why I said yes and no on the yes part, although our law does not specifically say that image rights are an intellectual property right, we recognize them as an intellectual property right, because as we all know, if you're looking at intellectual property and looking at the sources of law, the substantive law, being the acts and legislations that we have, are not the only sources of law that you can be able to go to receive, or to find out if a particular right is actually prevalent or is present or not. And so we have case law that has recognized the right to publicity. Not only case law coming from common law, because Uganda was colonized by the British, and so we received most of our laws from England and Wales, but our case law at the moment, and actually one of the things that I'm most proud of is that we happen to be the lawyers that represented the first successful image rights case in Uganda, which is, thank you. It's a case that really set the precedent, at least in Uganda, in recognizing that one, image rights do exist, and as such, human beings like you and I can be able to use our likeness to be able to sell and market products. And if another entity would like to use our likeness to market or sell their products, there's a reason why they're doing so, to the exclusion of other people. So there's something in our features, perhaps if I am the model, that would allow my likeness to sell the product that that particular person wants to sell. And so in that case, it was, for those that are, if you have any legal scholars here, Winnie Asege versus Opportunity Bank. And the judgment in that case still stands. It was appealed, but the appeal has not been successful so far, as far as I'm aware. In that particular case, it was established that every Ugandan has a right to publicity, number one, that if any likeness of any individual is used without the consent of that individual, or without paying any sort of compensation to that individual, but which really is tied to the consent, then there would be infringement of an intellectual property right, which in this particular regard would be the right to publicity. And so there are several other cases we've had in the past that have tried to discuss the right to publicity, but I guess the only, their downside was trying to link ordinary copyright or traditional copyright protection as we know it to image rights. And so you find that then, you find that the answer is lost therein, because then you're discussing copyright in general, and the tenets of copyright cannot, in the way that they are applied, relate exactly to image rights. And so we found that having a cause of action where you're looking at the right to publicity, you're looking at other causes of action like unjust enrichment, you're looking at other causes of action as well. I think, yeah, really those two, and unjust enrichment and the right to publicity, those have allowed us to be able to advance image rights in our jurisdiction. And now I feel that we have a lot more people being more intentional about, one, executing contracts that define the exact rights that they have. And number two, as well, you have more people aware that they have this right to publicity and would have recourse to court in the event that anyone used their likeness without their consent.
You've sparked a lot of interest now with this case, and I just want us to stay here a little bit because I've got things that I need to follow up on. The first thing is you keep mentioning the right of publicity. So I know that there are certain reasons why different jurisdictions name image rights, either image rights or right of publicity, etc. And if I look at the comparative studies that I've done, it is the US states that refer to the right of publicity as part of the right of privacy, or birthed out of the right of privacy. And so I wonder, was there a specific intention in this context in Uganda to use the term right of publicity instead of image rights? Was there an intention there? We can't hear you. I think you are muted. Let me unmute you.
Sorry, yes. Sorry, I had muted that could be able to give you to speak. Yes, that's a very good question. So ultimately, although our courts they usually take precedent from common law, because as I mentioned, that is the law that we apply. But there are instances, for example, if common law has particular principles that are better discussed in other jurisdictions, like jurisdictions that are applying civil law or even hybrid systems. And of course, the US, although it's not a common law state, some of their stare decisis has been used successfully in courts in Uganda. And we've seen that even in other causes of action, rather than the ones that are solely based in, let's say, intellectual property. But in this particular instance, why the law or why the courts decided to really use the term, as far as you've asked, the right to publicity, is that, one, in the way that we presented the case, we tried to show the court that this right is not just one that is only prevalent or commonplace in common law jurisdictions, but even in other jurisdictions as well. And so ultimately, whether we're talking about the right to publicity or image rights, we're talking about the same thing. And so the courts, thankfully enough, were alive to the provisions in other jurisdictions, like in the US, and how in particular they broke down this right to publicity. And in breaking down the right to publicity, we find that in essence, what they're doing is actually defining or breaking down how image rights are, the nature of image rights as we know them under common law systems. So the short of it all is the right to publicity and image rights are more or less the same. I'd say perhaps the key distinction that case perhaps tried to put forward is that with the right to publicity, you would have to have that element of, one, being a public figure, or being a figure where you have a sort of you're put on a pedestal in society where, yes, exactly. But the image right per se does not have to be attached to a right to publicity, in the sense that anyone, as long as I said, they have these special identification features, can still be able to succeed with the cause of action in that regard. But as long as you're presenting these arguments to court, really, in every sense, any judicial officer would still be able to link the two of them together, and perhaps just provide the distinction in as far as opposite counsel has tried to, let's say, deny that the plaintiff actually has the right to publicity. But under cross-examination, it's very difficult to go against that, because when you put any opposing witness on in the dock, and you're in the process of cross-examination, the question we ask is, why did you use Kenneth's image and not use another person's image, whether they are a celebrity or not? Why did you do that? And usually the answers, whatever answer they give, it will be that, even if they say that image was the one that was there, okay, but why did you select it? Let's say if you had other images. And usually at the end of the day, the overriding answer will be that that image was used because that person, Kenneth in particular, if I'm using myself in this example, has features that we felt would be able to sell our product better than another person would have sold them. And that, in my mind, enforces that right to publicity. Maybe just to segue a little bit, I also really understand that with social media, that right to publicity has now really morphed into image rights, because everyone now has, everyone can become a celebrity, whether overnight, but just the fact that I have a social media account and in the past, let's say only Ugandans would see me, if they're seeing me on let's say local TV.
Yeah.
But now with social media, someone in South Africa, someone in Kenya, someone in Egypt, somewhere in the US would still be able to see my image and likeness, and perhaps also be able to appreciate why my image and likeness has been used in a particular advert compared to another Ugandan who they could have used.
That's true. And I think this is exactly the challenge that we see with social media, that we can't really distinguish between celebrities and ordinary persons when it comes to image rights anymore, because of also how people's images are being used. I mean, in memes on a daily basis, deep fakes these days are also surfacing. So, it brings me to the point, the next question that I had for you, that how does these this kind of media that we see on social media, like memes and deepfakes and so forth, and all of these artificial intelligence integration on social media platforms, how do these affect the Ugandan approach to protecting image rights? I'm not certain if the judgment that you spoke about earlier was about image rights on social media or maybe offline, but can you just take us through the impact of these different innovations and digital media on the protection of image rights in Uganda?
Sure. So ultimately, I think technology has, of course, changed very many things. We live in the age of the fourth industrial revolution. And so you find, especially with the example that you gave around deepfakes, that you have people's images and likeness used in movies, used in computer-generated games, and so many other areas where they're using these images, and sometimes without the consent of these people. Now, you can't have a discussion around the use, let's say, of deepfakes or using images in that nature without talking about fair use. And if you're talking about fair use, because I think there's no jurisdiction in the world that does not have, Doctor, I hope I'm still audible. I noticed that the video is freezing a little bit.
You're still fine.
Okay. So ultimately, we can't have a discussion around the use of these images without looking at fair use. And now that's why really you can't divorce image rights from traditional copyright law. And anytime that we're talking about image rights, we'll still segue into copyright law, because I still believe that image rights fall under copyright law. And as such, maybe this is a discussion we can have. Should we amend all our laws to specifically reflect that right? Or I don't think there's need for us to have sui generis legislation when we're looking at image rights per se. But anyway, so ultimately, if then you're looking at fair use, you then go to one of the conventions I spoke about before, was the Berne Convention of 1967, which was the Berne Convention for the Protection of Literary and Artistic Works. And that convention basically introduced the three-step test, which is really a test that we use to be able to understand whether someone can be able to reproduce an image, reproduce a recording without infringing on another person's intellectual property right. And the test is that, one, that anyone who is protected, one, by that convention or even traditional local copyright law, shall have the right, and that right shall be an exclusive right, to authorize the reproduction of their likeness or image, if we're talking about image rights, in any manner or form that one does not, where that reproduction is allowed by legislation of that country. And we see, if you're looking at our copyright law in Uganda, that, as I mentioned to you, the law does not specifically talk about image rights, but if you're looking at copyright protection generally, you cannot share an image if that image is subject to copyright protection, and again, borrowing from the same thing, you can't share my likeness if, as long as, the law stops you from doing so if you don't have consent, or if you do not acknowledge, number two, where, one, that I am the person in the image or likeness, or that but ultimately it still goes to consent, that I've given you consent for you to be able to share my image or likeness, either with consent, in the sense that I have just given you that authorization, but where I have also paid you, or sorry, where someone has paid me some sort of compensation for my likeness or image to be used in the manner for which it is used. That number two, that reproduction should not conflict with the normal exploitation of the work, in the sense that if you use my image or likeness in a deepfake, does that take away, let's say, from in the manner that you have used it? Is, you know, are you in essence, let's say, prohibiting me from using my likeness in, let's say, an advert where maybe they're strict in the sense that my likeness should not be anywhere else? Are you infringing on my right to exploit my likeness in that manner? And then number three, if it does not unreasonably prejudice the legitimate interest of the author. So that's tied to the second one, in the sense that if I have interest in my likeness or image, and then you have these deepfakes or other forms of technology that are then using my likeness in a manner, even in memes, that are not, you know, that does not sit well, let's say, with my brand, because if we're looking at image rights, we're looking at my brand. My likeness is now my brand. And so the jury is still out on that one as to who would be allowed to do so. Memes, as you know, are one what we have discussed extensively, even in international copyright law, where we've seen that many countries now allow users to be able to share memes because they're sharing them for personal use. So even with deepfakes, someone can, I believe, still be able to use a likeness if it's used for personal benefit, perhaps as a parody. But in essence, especially with work over the internet, the question comes in, many of these people that are creating these things, they're creating them as content, because they're actually getting some sort of reward as a result of using that particular likeness or the deepfakes, whatever it is that they're using. And so if there is some commercial benefit, then I do strongly believe that that then prejudices the rights of the author or the rights of the owner of that particular likeness. And as such, that has made it difficult to be able to enforce image rights. So overall, I think many of these technologies have made it difficult. One, in the sense of maybe that particular person exploiting many avenues that they'd be able to use their likeness, maybe in ways, you know, if they were paid for those things, they would have been able to get more money. But on the flip side, I think they have also made image rights popular, because now people understand that using someone's likeness is something that, you know, would either sell whatever the person is trying to use my likeness for, or even if it's on the internet, some, you know, using someone's likeness would be able to get more likes or more content in that particular context that it is used. And so you find that on one hand, it has, yes, it has made it difficult for authors to exploit that part. But on the second hand, it has made these image rights popular. And that's, honestly, I don't think would have succeeded in the case that we did had the court not have taken judicial notice of the fact that social media in particular, or advertising, really is successful solely because of these images that they use to be able to promote their products or brands.
Wow. You know, one of the things, the arguments that I advanced in my doctoral thesis is that if you look at the way memes are used, even in marketing, and the fact that there are people who are also paid for memes, and also the fact that in South Africa, for instance, we've got social media pages that are particularly dedicated to memes. I built the argument that even without monetary exchange, the mere popularity of a page that is built on the use of people's images in memes, that is actually a commercial exploitation of people's identities.
Yes.
And I argue that there's a clear challenge for the law here, because I consider how a number of jurisdictions will remedy publicity and image rights through tort law or law of delicts, basically, where you claim compensation. But what about the instances where you can't really prove that there is loss, but there is evidence that a meme made someone famous. These are things that I pull apart in the doctoral thesis to say that, you know, the social media context is really challenging the way in which we regulate image rights, because we developed the jurisprudence, particularly in South Africa, we developed it in the world of advertising, traditional advertising, like newspapers, magazines, and stuff like that. So we never foresaw how social media will change some of the questions that we have in mind. I could also make an example about a public figure who wanted to claim the violation of image rights for a caricature that was made of him. Obviously, in a constitutional democracy like ours, the right to freedom of expression trumped his image rights. But I consider, what if that wasn't a caricature? What if it was like a deep fake? How do we protect public figures in such context? Because the impact of a caricature on people who observe is different from the impact of a deepfake. One could really believe what they see in a deepfake. And we need to think carefully about how we protect even the image rights of public figures in such contexts where AI can distort reality or can distort what we see. So these are very interesting questions that I feel present a lot of challenges to the way in which we traditionally protect image rights. You know, and I was interested in the case that you actually referenced. I wondered, was it a context of traditional media, or was it an online issue in the facts of this case?
So that was actually in the context of traditional media, but of course, since this was a matter that was decided in 2019, there was also evidence presented that although that used her in traditional media, it was also that the images were still shared online, and that really helped to be able to increase the damages as they were given at the time.
Wow. Okay, interesting. Now take me to before this judgment, because I know in certain jurisdictions where there's no outright recognition of image rights, there will always be you know, litigation trends that point to the fact that legal practitioners go the privacy protection route, especially when they deal with non-celebrities. So take me back to before this judgment, before there was an outright recognition of image rights in Ugandan law. What were there cases like this that were dressed up as privacy when we could all see that this is really image rights, or maybe dressed up as passing off in the context of celebrities, even though we could see that this is image rights? What was the landscape like?
So as I mentioned to you before, most of the cases that came up before this particular case, somehow the focus remained on copyright infringement for some reason. But there it was difficult to enforce a copyright infringement claim, because ultimately, if you look at, as I said, the wording of the law, there was, you know, image rights were not recognized as copyright. And so really, it was difficult to say that there was any infringement, because even there's a case called Sikuku Agaitano versus Uganda Bati, where this is where Uganda Bati is a company that manufactures iron sheets and other steel implements. And so they had informed their employees that they would be having a tour and they'll take photographs basically to show the products. And so Sikuku was one of the employees at the time, and they used this photograph and used it basically to show the products of the company. And so he took them to court. But his claim in court was for copyright infringement. So then the question court asked is, does Sikuku own those photographs? The answer, of course, was no. So if Sikuku does not own those photographs, why is he in court? And of course, the lawyers could not be able to answer a question in a manner that would be able to save their client, and the case was lost. There's another case which was similar. This one was against MTN, I think, which is also in South Africa, where a person's likeness was used on a particular billboard, but the person was not the subject really of the advert that was used. They were in the background of that particular image. So I think it was Basajabaka versus MTN. So I remember this case because I teach intellectual property as well. So we've discussed many of these cases in class. And so in that particular case, Basajabaka, the question again was one, in that one, at least they tried to go under passing off. But the question was, if someone is not in the foreground of an image, if they're incidental too. Now, if you borrow from the right to publicity, especially in the US, many of those cases have mentioned that if you're not the subject of the advert, then that can be a defense that perhaps you are just caught in everything else, especially if you can't be clearly identified. And so this particular individual, I don't recall what the final judgment was, but I do recall. No, actually, yes, that particular individual was not successful in that claim solely because they were not the subject of that particular image. So those, unfortunately, are the only cases we have, or that I could be able to get from our jurisdiction in Uganda that looked at image rights. Most of the other cases looked at little aspects of image rights, but really in the form of copyright infringement, that where now someone's photograph is actually used, where it happens to be that that person is also the one in the photograph. And so it ties to image rights, but where the judgment, the final judgment, does not really go into image rights per se. So that's really we haven't had much jurisprudence in Uganda when it comes to image rights, but I don't know why that is the case, because usually, of course, as we know, laws usually reflect the society. I think that's something that Kelsian following philosophers will be able to appreciate. And in this instance, although our society has had image rights for a while, even before the internet, we had billboards, as you said, we had magazines, we had newspapers, and we had people in these particular forms of media whose images were used, but somehow I think maybe because they didn't know that they could be able to take these people to court, or it became an aspect of breach of contract where a model is perhaps taking an advertiser to court, or is taking a newspaper to court because they have not received compensation as a result of them providing services as a model. And so I think that's why the 2019 case, that Winnie Asege case, was the first case in our jurisdiction that really discussed image rights the way that we understand them, and that really we feel that now there should be more cases coming up. By the time we're having this discussion, I did check to see if there were any other cases that had followed, but at least from before, those cases I mentioned to you are the ones that talked about image rights. But I feel the subject really went away from image rights and now went to copyright infringement.
Wow. So the frustration I have typically in South Africa is that instead of it going copyright, it goes to privacy. So privacy overshadows image rights quite often. And what I'm seeing now is that there's a very high possibility that data protection is also going to start overshadowing privacy. I mean, when I, for instance, present papers and stuff like that, people always ask me, why aren't you looking at data protection? And I have to remind them that our data protection laws have a concentration of private and public bodies, what they do with data, not really the one-on-one relationships where image rights violations normally crop up. So it's quite interesting that across different jurisdictions, we've always tried to avoid to have a substantial image rights regulatory framework, at least a sui generis type. And I think the way in which social media, AI, etc., are all operating, even with the drones in the picture, I think they're raising a call for us to pay attention to image rights. Now, you know, there isn't a point where you've touched on the Constitution, and which brings me to my next question, because I know in South Africa, our image rights, which is known as the right to identity, it stems from dignity, our common law dignitas, and that's also it's embedded in human dignity under our Constitution. And so I wondered, what are the constitutional values, rights, and imperatives in Uganda that could have an impact or influence the way in which the right of publicity is even adjudicated on in Ugandan law?
Thank you. Actually, you've just pointed out something that I was not aware of. You're right. Everything I've mentioned, I've not mentioned the right to privacy. And yet image rights really stem from that right to privacy. But I think The reason for that is, as you've mentioned, somehow, whenever we talk about the right to privacy now, we liken it to data protection and privacy. And so maybe the question I'd also ask you, especially with other jurisdictions that you have looked at, do you think an image would qualify as personal data, as a personal identifier, if you try to expand the scope?
I would say that it depends on the particular legislation that you're dealing with. So for example, in the Protection of Personal Information Act, in our laws, the definition of personal information does not limit itself to data. So it goes into your name, your ID number, and stuff like that, which gives us the grounds to say that even your image then is actually personal information for purposes of our legislation. But even so, the scope of application of the legislation would not allow an individual to sue another individual for using their image in a meme on social media, for instance. It's only if, for example, you had a major company that falls within, the scope of the act that is busy using people's images in such a way, because then there'd be definitely processing of personal information in that context. So I honestly think it depends on what does the legislation say in the particular jurisdiction? What is the definition? Is it using personal information? Is it calling it data? Because that is key here.
I'd actually be very interested if someone filed a suit in that line and courts actually give us jurisprudence in this area. In any jurisdiction. If anyone does do that, doctor, please do send it to me. I'd be very interested to see how the court broke that down. But generally, yes, in Uganda, of course, the constitution is our supreme law, and the constitution does provide for the right to privacy as a fundamental human right, which in our jurisdiction is non-derogable. You can't take away my right to privacy. However, ultimately, so the law in Uganda regarding image rights, yes, does stem from our constitution, in particular, that right to privacy. And of course, you can even go further to the ICPR, which is the right to be let alone. And ultimately, why it's even necessary, I guess, is even outside of what we talk about, even into data protection. If you look at the African Union Convention on Cybersecurity and Personal Data Protection, it also still somehow, segues into the importance of that right to privacy, extending as well to that right to be let alone. And that right to be let alone includes the right for you not to use my image in a manner that would infringe on my right to privacy. So image rights, the cause of action for image right infringement or the right to publicity, I feel in every sense really has developed as something that's come from our constitution and has come from that right to privacy. But our courts, in essence, have in many cases only looked at the right to privacy only in human rights disputes. So if someone, let's say, is taking government to court because they're being surveilled, or if someone is taking government to court because they feel that that human right, in as far as maybe government has installed surveillance equipment that would make them feel like they're being watched all the time, or if they're party to particular proceedings, for example, and those proceedings if they're applications where a court has agreed, let's say, that we're going to keep these proceedings in camera, we're not going to disclose who the parties are, and then a leak comes as a result of that, and then you get to know who is subject to this investigation or this. That's where we have jurisprudence in that particular line. But in regards to image rights per se, we did use that cause of action. Actually, the right to privacy was among was really what we started with in order for court to have a grounding to know that, okay, even before we go to the US, even before we go to the British common law system and get any cases from there, why don't we start with our constitution? In the past, we've looked at the right to privacy, as we said, as a human right. But although it is a human right, let's look at it now in the commercial sense. The constitution does not specifically bar you from having a cause of action that would try to enforce commercial rights or commercial obligations as a result of a breach of that right to privacy in a manner that is tied to the right to publicity or the right for my image or for my likeness to stay with me and for that privacy to be entertained or to be sustained in as far as I want that to. And so really, if you're looking at our constitutional law, yes, the right to privacy is one that is enshrined in our constitution, but I'm actually shocked that we haven't had a lot of jurisdiction where lawyers have brought out the right to privacy related to image rights even before the cases that I have mentioned.
Yeah, it's actually something that I'm noticing is quite different. It's unique with Uganda. If I compare it to South Africa, the US, even if I go to UK, I'm thinking Nigeria as well. All these other jurisdictions have had this debate about privacy and image rights. But for some reason in Uganda, it's gone the copyright route mainly. I know in some states in the US, there's also been a bit of a copyright element coming into the picture, but it's not as prominent as the privacy debate. The last position that we have as it stands with the Khumalo Basetsana judgment is that our courts are not willing to finalize the debate about whether a use of someone's image is a violation of privacy or image rights. So what you have is people bringing in claims on the basis of both rights, like in the Khumalo judgment, which she actually won on the grounds of both rights, and the court refrained from even ruling on whether this is primarily privacy or image rights violations. So we've got this lingering. Yeah.
So sorry. Yeah.
Yeah, I was actually going to just say we've got this lingering debate, which I argue that in social media, the way things happen, it helps us to draw a line between privacy and identity. Because, for instance, in January, our Supreme Court of Appeal actually ruled that once you post your stuff online and someone else reuses it, you may have not anymore, you may not have a legitimate expectation of privacy anymore, which is really that test for privacy under our constitution. So I argue that, but image rights don't look for a legitimate expectation of privacy. And so perhaps in this era, they offer much more protection than privacy can. And if you look at things like the way in which data protection legislation is coming up in many jurisdictions now, I don't think we should conflate privacy with data protection, because data protection really it doesn't really protect us from people using our information. It just says, if you're going to use people's information, have permission and do it in an ethical way. Hence there are conditions for processing about fairness, openness, and data participation, etc. So that's really not giving us the core privacy that we've had in our constitutions, in our various constitutions. So I'm skeptical about privacy today. Maybe I'm biased. I prefer image rights because I think they have a lot more to offer protection-wise on social media, especially. Yeah.
No, I agree with you. And what I was just going to add to that wonderful submission is that in Uganda and most of the countries, I learned recently, well, this is even right outside image rights, that I don't know if you're interested in consciousness or any discussions around the expansion of consciousness, or how as human beings we are conscious and perceive the things that we see the way that we perceive them. But I found out recently that babies have what they call lantern consciousness, where they can't focus on one particular thing the way that an adult can. And so the older you get, the more that you have that more focused or spotlight consciousness that allows you to be able, well, to perform many of the tasks that we can perform, but in a manner as well that allows you to be able to think through these tasks. That's something that a child or baby would not be able to do. Now, if you relate that to law, you'll find that if the law has given you a particular context that this is what you should focus on, and any discussion really should be focused in these boxes that we have given to you. Our Article 27 of the Constitution says that no person shall be subject to interference with the privacy of that person's home, correspondence, communication, or other property. Now, if you read it the way that it is, any jurisprudence that we've had in our jurisdiction, the reason why perhaps privacy has been tied to human rights in the past is because you're looking at it, the Constitution, which is the supreme law, is guiding you and saying that look at privacy in regards to interference with correspondence or communication or property. It's only now that, of course, ultimately these particular laws must stand the test of time, that we're using that or other property to determine, okay, if you're looking at other property, is my image my property? And that's where now that discussion has, has now come in to introduce image rights likened to, to privacy. But I don't think really I would fault our judicial system or even our lawyers, as to why they were not doing so. But I do agree with you. I feel, and perhaps that's why even as we're talking, I preferred, or I still prefer, just like you, to state or to look at image rights as image rights and separate them from privacy, because privacy has so many other considerations, and that may be able to take away from, from the point that you're trying to look at. So I feel it is, it is an undoing as humans or as Ugandans that we are focused on that, because that is the nature of our minds, that's the nature of our consciousness, that's how we perceive things. But ultimately, I feel that that has also worked for good, because that has then allowed image rights to come out as a separate right, where you can liken and use the right to privacy to be able to buttress or to be able to supplement the case that you have. But ultimately, the law will decide on whether that right that you have, which is the right to publicity, the right to use your image in a manner that you have used it, that should stand alone. And in my mind, as you have said, should not be mutually exclusive to privacy, the way that we have looked at it.
Wow. Kenneth, we could go on the whole day. I'm really enjoying our conversation, and I'm hoping that we can actually collaborate on this issue, because I'm hearing a lot of questions coming up, not just about the mere application of law, but how do we interpret certain even terms that we use in the space, because that's quite important. So I'm quite interested in hearing more from you after this interview. But before we end this discussion, for our listeners, I think, do you have any last words, maybe tips or statements you want to make to photographers, influencers? What should they consider when they navigate contractual relations that regulate their image rights? If you can leave us with maybe a word or two.
Yeah, sure. I think the most important consideration is to understand that image rights are rights that are recognized by our legal systems. And so as an artist, as a model, as a photographer, you must be alive to that. If you photograph someone, if you use someone's image or likeness, whether in a photograph, in a painting, in a deepfake, if we're using, sometimes we look at deepfakes only in the negative, but there are times when deepfakes have actually been important. So if you're doing so, recognize that that every person has that right to publicity. And there's also a reason why you're using that person over another. You could think it's perhaps the setting you're using, that you're taking the photo, but ultimately the person is still in the photo. So it's very important to be alive to that. Number two, if you use someone's image, if you use someone's likeness, make sure you have a contract that determines what or how you'll be able to use that image or likeness. If you don't have that contract, then you stand the risk that you're going to be sued. And if you're sued, most likely you find that all your hard work will go down the drain, only just because you were stubborn and did not want to document exactly why you want to use that person's likeness, how you're going to use that likeness, and if you're using it for commercial gain, how much you're going to pay that person for being able to use the likeness. So I would say really those are the two, to recognize that image rights are right, they are a thing. And number two, if we recognize that, let's make sure we have contracts that you sign with anyone who you're going, whose image or likeness. And that image is not just facial, can also go to voice as well, that if you're going to use a person's voice, make sure that you have an agreement that determines the rights of each of you in relation to how you're going to exploit that work. If you do so, most likely you'll be able to exploit it in a manner that will be beneficial to everyone concerned.
Thank you so much. So where can our listeners reach you? Are you on LinkedIn, Twitter, perhaps?
So I'm on LinkedIn, Kenneth Muhangi. I'm on Instagram, which I use a lot, but usually Instagram is, if you want to come check out my other life, other than the life where I have a tie here. I'm also on Twitter as Kenneth, but really, if you want anything relating to the law, anything to do with that, I think most likely LinkedIn would be a better platform to be able to do that. But since really the law and life really coexist, I am not a lawyer just when I come to office. I am a lawyer and I am an advocate till the day I die. And so you'll find that even when I post on Instagram, on Twitter, you still have many references to the law as well. So you can be able to reach me there.
Thank you so much, Kenneth. Thank you for coming and gracing us with, you've got a lot of insight. I love the fact that you've got a lot of insight on also intellectual property law, in addition to all the other issues that we're discussing around image rights, because I think our audience need to understand that image rights is not really intellectual property law, but the two do tend to interplay, it's important. So thank you so much for coming through today.
Doctor, I just want to say really thank you very much for having me. They say really energy takes the path of the least resistance. And I think I've really enjoyed this because we have the same mind. We've been vibing, Doctor. And so I feel that that's what has made this discussion very interesting. And I'm really looking forward to having more discussions with you. I'd also really want to read your thesis, if this is something you're free to share. Or I would really love to read what you wrote about image rights. And I'll definitely look out for more things that you've written, that we can be able to interact more on this topic. Thank you very much. Thank you.
Remember to control your image rights.